All right. Welcome, everyone. I appreciate you bearing with us as we work through all the technology. That's great, but it's also oftentimes requires some extra steps. So thank you for weathering all that and being with us this morning. This is the regular scheduled meeting of the. Oh, there's Miss Morgan. Thank you, Miss
Here
Morgan.
I
I'm glad
am.
to have you. We
Thank
just got
you.
started, so you haven't missed anything.
Okay, thank you.
Yes, ma'am. All right. So we'll call this meeting to order. Let's go ahead and start with the roll call and establish quorum. Britton Collins,
Here.
Judge John Rambo,
Here.
Marilyn Morgan,
Here.
Brandon Pettis,
Here.
Stephanie Branham.
Here.
All right, great. We do, well, let me go ahead and finish our roll then. Corey and Neal, Ken Mansfield. All right, so 2 absent, 5. We have quorum. We'll move on then to the notice of meeting. Notice of the March 26, 2021 meeting of the Court Reporters Board, including date, time, and location, has been noticed on the website since September 28, 2020. Additionally, this month's agenda has been posted on the website since March 12, 2021. As you know, with any of our remote meetings, we always have to do a statement of necessity, and then all of our votes will be roll call votes. So when we do that vote, if you move with any motions, you could just identify yourself and what that motion is. That would be greatly appreciated. The statement of necessity. According to TCA 844-108B2, if a physical quorum is not present at the location of a meeting of a governing body, the governing body must file such determination of necessity, including the recitation of the facts and circumstances on which it was based, with the Office of Secretary of State no later than 2 working days after the meeting. Furthermore, TCA 844-108A3 defines necessity as matters to be considered by the governing body at the meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is the regularly scheduled meeting for the Tennessee Board of Court Reporting, and the purpose of today's meeting with the members attending by WebEx is to discuss the agenda as noticed on the website earlier. So if we could get a motion to accept that statement of necessity, we'll get that filed over there per the requirements. Do we have such a motion in that regard?
This is Marilyn Morgan. I make the motion to accept the statement of necessity.
Thank you, Ms. Morgan. We have a motion from Ms. Morgan. Do we have a second?
This is Brandon Pettis. I second.
Thank you, Mr. Pettis. For roll call vote, Britton Collins,
Aye.
Judge Rambo,
Yes.
Marilyn Morgan,
Yes.
Brandon Pettis,
Yes.
Stephanie Branham.
Yes.
All right, thank you. We'll get that filed over there promptly then to the agenda. Of course, you guys have all the documents in front of you. Is there any amendments to the agenda? Is there any comments or edits or anything that you would like to include or add or move around? Hearing none, then we'll entertain a motion to accept the agenda as printed. Do we have such a motion?
Stephanie Branham, I move to accept the agenda as printed.
Thank you so much, Ms. Branham. We have a motion to accept the agenda. Do we have a second?
Marilyn Morgan, I second.
All right, we've got a second from Ms. Morgan. Roll call vote, Britton Collins,
Aye.
Judge Rambo,
Aye.
Marilyn Morgan,
Aye.
Brandon Pettis,
Yes.
and Stephanie Branham.
Yes.
All right, thank you. All right, September minutes. It's hard to believe it's been that long. We've covered a lot of ground since then, but upon review of your minutes there, if that comports to your recollection of either your attendance there or your understanding of what transpired, or your review of the electronic record as well, we'll entertain a motion to accept, or unless you have any edits or comments, we'll entertain that as well. Do we have any edits, comments, or revisions? All right, hearing none, we'll entertain a motion to accept the September minutes as written. Do we have such a motion?
Chancellor Rambo, so moved.
All right, thank you, Judge. We have a motion from Judge Rambo. Do we have a second?
Stephanie Branham, I'll second.
All right, thank you, Ms. Branham. For roll call vote, Britton Collins,
Abstain.
Judge Rambo,
Yes.
Marilyn Morgan,
Yes,
Brandon Pettis,
Yes.
Stephanie Branham.
Yes.
All right, thank you very much. We'll get that filed then. Okay, on to the director's report. All right, of course, this is the budget is just informational purposes only, nothing, no action items there. Well, typically I try to give everyone a snapshot, sort of high level view first, and then we fly down and take a core out of the total health of the budget and look at this fiscal year, but as it's trending. But we try to start with the big picture first. If you're looking at the reserve, that's that first page. As you know, our even years are our renewal years. So you always see you'll see us in surplus on those years. And then the odd years, you'll see us in deficit. This being an odd year, when we move to the second page, you'll see that that's trending about on par for the course. That's where we will run a deficit until next year when we have another renewal cycle. If you look at the first page again, let's look at fiscal. You see this one big at the very top portion or section of your page. You'll see one big expense, that 59,000 under computer related items. That was fiscal year 17 through 18. That was us coming onboarding to core. And of course, you remember that seems like a million years ago, but yet just a couple years ago, we've been on core, and that was our big expenditure there. You track on down over to this current fiscal year, you'll see that the total expenditures are 18,400 roughly. Total net revenue is 80,270, leaving us a fiscal year balance of 61,000, adding to the overall reserve balance, leaving us a reserve balance at 193,910. Of course, that was a licensing or renewal year. So of course, we're going to add to that's about on par for what we normally generate for each renewal cycle. If you move to the second page, let's take a look at there. If you look on July, you'll note that we were in the positive there. That those are revenues coming in still for the renewal cycle in June. As you know, June 30th is that deadline. So you'll have some expired grace. You'll also have some payments that don't get posted till after the fact. So that's why we're in the surplus there, but then we're in a deficit from here on out. And we will be until the end of this fiscal year, until next year, right into about probably April, May, June again, you'll see it pick up and get back in surplus. So nothing outside the ordinary. There is one item I just want to draw your attention to. August 20th in the revenues, you'll see basically a cost back. There was a spike in revenue for June and July, as you know, due to the biennial renewal cycle. The revenue received in June was paid in July through credit card statements. And so as a result, July revenue was overstated by nearly 14,000, resulting in that reallocation in August. If you look down in the historical trends in the last renewal cycle, same thing happened at that renewal cycle. So there's nothing that I see outside the historical trend there. So that explains why the larger deficit during that month than you would in other. That's just those credit card payments being basically posting after the fact, but being reported in the off month and thereby being reallocated. Other than that, it looks like it's business as usual. Is there any comments, questions as a result to the budget?
Glenn, this is Britton Collins. I have a question.
Yes, sir.
Is there anything that y'all are anticipating from commerce and insurance that's coming down the pike that will be an expenditure, in line with what we saw when we onboarded to core? Any major expenditures like that y'all are aware of coming down the pike?
That's a great question, and I understand why you would ask that. And no, sir, there isn't. That was the big one. That was coming into core. There's always enhancements typically that will sort of be codes that will be dropped, but then that will be shared throughout all of regulatory boards, and you'll see that in administrative cost backs under the technology and other column. And if and when we catch wind of those, then those will be explained, and then I'll detail that out. right now, I don't foresee anything. There's nothing in the pipeline that I'm aware of. We have one enhancement coming, but nothing in the way of that 59,000. That was the big expense for the program. We shouldn't see anything like that again.
Yeah. So, and I think every meeting, or at least every meeting when we go over the budget, I make the same point, which if you extract that out, that $60,000 expense from fiscal year 17 and 18,
Mhm.
it seems like we have too much money. And I understand that we're on a 2-year cycle. But even considering that, it seems like at the current pace, our reserve balance is going to grow by, $40,000 to $60,000 over every 2-year period. Because it just, our expenditures just aren't that much. In a normal year,
Right.
they're $20,000 to $30,000. So, in a 2-year period, we're incurring $50,000 to $60,000 in expenditures, but our revenue is, $80,000 to $90,000 over that same period. We've already got $190,000 in the reserve balance. Even if we got hit with another core expense, we've got the money to cover that. And so it just seems like we're going to continue to accrue, a pretty substantial reserve balance compared to what our expenditures and anticipated expenditures are going to be. And so, under that circumstance, it seems we have 3 options. We can just continue to accrue money, at the expense of the court reporters in this state. 2, we can establish the indigency fund that's suggested in our statutes, or we can reduce licensing fees, renewal fees, some of our fees across the board to, kind of slowly return that money back to the
Yeah.
court reporters.
I'm glad you raised that point. Actually, number 3 would probably be the direction, as we've seen across many of our programs. So what they've asked from us in all of our programs in the sunset hearings is that we maintain operational budget in the reserve of about 2 years, and then when we hit that threshold, then we start discussing fee reductions. So they are tracking that in fiscal and then through accounting. So to your point, they are aware of that, and we're not in the habit, as you know, and with any of our programs of collecting on reserves. It's a very tender balance. You have to maintain sort of a fiscal viability and solvency and projected, and while giving yourself enough padding to absorb some of those administrative cost backs that invariably come down the pike, or in those sort of enhancements that you just described. So you're not wrong. You're definitely dead on where we're tracking. But if we exceed beyond that threshold and then exponentially at a pace that we believe will continue to accrue, then we'll be having those discussions about fee reductions. And we've seen some of that in some of our other boards already.
So will that be something that once we cross that threshold and some internal bell is rung at
Yes,
Commerce
sir.
and Insurance or at the legislature that, hey,
Mhm.
we've exceeded that, is that a discussion that you all will initiate at the appropriate board meeting?
Absolutely.
Okay.
Yes, sir.
With recommendations for
Mhm.
what to reduce and where and when?
Yes, sir. We had one of those just recently in private probation. As a matter of fact, we got rid of a late fee, and then also there was a minor administrative reduction there as well. So, and then
Okay.
we did that in the form of a rules. We would roll that out. We say, look, this is what we're projecting. We think that this will sort of level it off, and this is how we're solving that. And then here's the rules for your approval. And so then they had that discussion there, and that was just, I believe, November of last year.
Okay. All right. Well, I'm satisfied with that from my end. So if nobody else has anything, then I don't have any other questions or comments with respect to the budget.
No,
Thank you.
I always appreciate the comments. Thank you, Mr. Collins, and for many others as well. Those are good stress tests for us, and it helps us all stay on the same page and gives us an opportunity to have that discussion. So glad we were able to do that. If there are any other questions or comments, I think we're able to move on to the next item. Are there any other statements? All right, election of officers then. All right. TCA 29604F states that at its first meeting each calendar year, the board shall elect the chair, vice chair, and secretary from its membership. No member shall be elected to serve more than 2 consecutive years in the same office. As a result of that statute, we're required at our first meeting to have an election of officers. So as is common, it is that time of year again. Just so you know, our current chair is Marilyn Morgan, vice chair is Judge John Rambo, and secretary is Corey Ann Neal. As for the second provision of that statute, none of these officers have served in the same position the year prior and are eligible to serve another term. So with that being said, you can either reinstate them or come up with a whole fresh batch of officers. That would also be well within your prerogative. We'll entertain any motions in that regard, and I'll try to track those. Do we have any motions or nominations rather, I guess is what we need to start with.
Glenn, just to confirm, you said all the officers are eligible for re-election for the next term?
Yes, sir. That's correct.
Well, I will renominate Miss Morgan for chair.
Okay. All right. Do we have anyone for vice chair? Does anyone want to nominate for vice chair? Right now, that's Judge John Rambo.
This is Britton Collins. I will nominate Judge Rambo to serve a second term as vice chair.
All right. Thank you, sir. Now for secretary, we have Corey and Neal. Any nominations in regards to secretary?
This is Britton Collins. I will nominate Corey and Neal to serve a second term as secretary.
Thank you, sir. Since we have nominations for the current membership and then their leadership positions to continue in that regard, do we have a motion for another term for the current leadership?
I'll make that.
Collins. Go ahead, Judge.
No, go ahead, Mr. Collins.
This is Britton Collins. I move for the current nominated slate of officers to be elected to those positions for the current year.
Thank you, Mr. Collins. Do we have a second in that regard?
This is Brandon Pettis. I second that motion.
All right. Thank you, Mr. Pettis. All right. We've got a motion from Britton Collins to re-elect the current officers to serve in one more term since they're all eligible. Those officers being Chair Marilyn Morgan, Vice Chair Judge John Rambo, and Secretary Corey and Neal. We have a second from Brandon Pettis. For roll call vote, Britton Collins.
Aye.
Judge John Rambo.
Aye.
Marilyn Morgan.
Aye.
Brandon Pettis.
Aye.
Stephanie Branham.
Aye.
All right, thank you very much. All right, moving on then to application reviews, reciprocity. Okay, let me pull up that document. That will be document number 4 on the documents that were provided earlier. Okay, TCA 29610 grants the board to enter into reciprocal agreements with other states to allow for licensing of their court reports if that state's requirements has substantially the same or more stringent requirements. Today before us, we're looking at Michigan for reciprocity. You should have a one-page document in front of you with their listing of designations. All right, and we'll open the floor for discussion. Are there any comments or regards to what you see before you?
This is Britton Collins. One question that I had, sorry, let me find, you know, if you look at our regulations with respect to the examinations that are acceptable for the different classes of licensure that we have, it's made very clear in our regulations that the examination or which examination is accepted, and all of those are examinations administered by one of the national court reporting associations. When I look at the certified electronic recorder classification from Michigan, bullet point 2 says proof they passed the CER certification examination.
Mhm.
And unlike the other classifications in Michigan that make clear that those are that's an examination administered by the National Association, that's the same one that we authorize. It's unclear on that front whether the CER certification examination that's accepted in Michigan for the certified electronic recorder is the same national examination that we approve, or whether, it could be something else. And so I guess I'm a little concerned
Mhm.
that in the absence of that clarification, that it could potentially be a different or lesser and less stringent examination, than what we require.
Correct.
And so I guess I would be asking you all for whether y'all know if that's accurate.
Yeah, that's
Or
a great
not.
question. No, you're on the right track, sir. And they do that. They've added an online CER course at Lansing Community College. There's a link attached there to. Not being a court reporter, I'd have to, of course, defer to the board in that regard as to see if those requirements are substantially the same or more stringent than AAERT requirements. I would welcome the discussion in that regard.
This is Marilyn Morgan. I think we probably need to do a little research on it. We went through this with the AAERT. We're
Mhm.
requiring them to have the CET, the electronic transcriber, as well as the certification for, we're requiring them to pass the test for transcribing as well as working the electronic equipment. So I don't know if this CER is merely electronic equipment or includes the transcription part. We probably need to look at it a little closer. I'd be happy to.
Sure. And one thing, and we made something to consider as well. We did pass the rules to add the CET, but as a part of our rules update, Hugh, are you available? Are you nearby? We may,
here.
if you're
I
okay
am.
to, yeah, if you're okay to do that rules update now, that might be informative to the discussion we're currently having in regards to reciprocity.
Okay. Yeah, so for the
Other,
rules that we passed, currently the AG's office has approved the rules. However, there was an amendment that had to be made, and I researched it as much as possible. But the additional CET examination was removed from the rule change because it adds an examination requirement for individuals who previously could have qualified only with the CER examination. So in order to push the rules through, the only change that is going to be made is the changing of the word shorthand to untranscribed in the sentence shall establish a plan for the security and preservation of untranscribed, notes and any backups, both paper and electronic. And those are the rules that are under the standards of professional conduct. So
yeah.
if you have any questions on that, be glad to answer them if I can.
Thank you, Hugh. I'm sorry we had to kind of get things out of order, but it just seemed like since we are discussing the CER here in Michigan, that was appropriate for context to go ahead and introduce that as well. So we won't be able to do the CET like we had all originally had thought and planned and hoped for. Attorney General's office shot that down since it was inconsistent with court reporter board statute, which does not have that CET required and specifically names the CER only, to Hugh's point. So we wouldn't be able to make a rule to add the CET. So it stands currently with the AAERT CER only. So with that in mind, Now looking at Michigan's requirements, and then if you go to Lansing Community College, their description does say become a CR and record court proceedings as well as the ability to produce transcripts. So even though our statute doesn't require that with the CET, their training for them to get the CR does. So there could be an argument made that it is substantially the same or more stringent. Of course, that would argument that you would have to make or that you would have to defend or rebuke one way or the other based on your expertise before you.
Yeah, and this is Britton. I guess just to reiterate my concern, you know, with respect to the electronic reporting, under our regulations, you know, we accept. It seems only the examination administered by the American Association of Electronic Reporters and Transcribers, and it is not clear that the CER certification examination administered in Michigan is that same exam. And so, you know, while I understand that they appear to have some, and perhaps even more robust, you know, training requirements, as they describe in bullet point 1 under their certified electronic recorder, it's just not clear to me that the examination is substantially the same as ours, and so that's where I'm concerned, and I guess where I was hoping for the clarification. Although I know that there's some other folks who I guess have expressed concern about whether they could just record versus transcribe. Glenn, is there anything that would prevent us, you know, if we look at the certified stenographic reporter and the certified stenomask reporter requirements for Michigan, you know, they do appear to be, at least from my overview, although I would welcome some of the court reporters' insight on this, they do appear to be substantially similar to the requirements that we have. Would it be possible to, you know, at least as it relates to today and doing something today, to certify reciprocity for those two designations, but to withhold reciprocity with respect to the CER designation until we get clarification on the examination?
Absolutely. I appreciate your pathway there. We could certainly do that, and it would be recommended too to keep those that you know, we don't want to, of course, unnecessarily extend the application process for those that might want to come through with the CSR, CSMR as you described. So we could do that, and then of course I could get more information from the program to satisfy those concerns as articulated by the board. Certainly we could do that. We would just need a motion to accept the CSR and the CSMR through Michigan as for reciprocity, if that was the will of the board.
Hey, Glenn, this is Stephanie Branham. I have a question about the CSR. Can you hear me?
Yes, ma'am. Thank you.
Okay, perfect. So the way I'm reading this is that for the CSR, they would have to have all 3 of those requirements. Is that correct? Or
That's
is
correct.
it one? Okay. I just wanted to make sure I'm
It
reading
is.
that correctly.
And so as you can see, if they've already got the RPR, they would have met our requirements. So they're meeting our requirements, and they're passing the Michigan CSR as well, which, you know, just functionally, we could just ask for the NCRA and be done with it. But without having that extra step, you know, we could get the CSR certification, the letter of good standing, and that would be enough without having them force them to go back and show us their test results, because obviously they have already done that through number 2, to your point.
Right. I was concerned that if all they had was number 3,
Right.
the CSR, it says written examination, and that's not the same. So that's why I wanted to clarify that. Thank you.
Oh, yes, ma'am. Thank you. Good point. Yeah, that doesn't say or and, does it? It's just 3, as if it's right. Any other questions?
And then, Glenn, this is Britton. Just one more question. Once we grant reciprocity, they will then be subject to like the the Tennessee CE requirements in order to maintain and be eligible for renewal of their Tennessee reciprocal license. Is that correct?
Correct. Yes, sir.
Thank you.
Yes, sir.
This is Marilyn Morgan. I'm still concerned with the electronic. And will the Attorney General revisit what he's turned us down for on the AAERT, the CET certification? That's really just enabling someone to take their electronic equipment and then they hand it off to India or somewhere to transcribe.
It would require a departmental bill because it is a statute. So not to say that that's a problem, but that's a little bit more of a process than the rules itself. It would have to be sponsored. So if there was a legislator that would place that on one of their bills during legislative session, we always make those recommendations. And to your point, this is something that we would track and that we would recommend as a department. But then whether or not that gets picked up, obviously we can't sponsor our own bills. We're just a source for them. We're subject matter experts and we defer, of course, to the boards. But if a legislator, your local rep or senator or someone was to sponsor that and include that in a bill, certainly no problem. That would move and wouldn't need any action from the board and that would be done. But right now, the Attorney General, based on rules of process, could not let us go forward with this rule since it is in contrast to statute.
And you're saying you think that the CER for Michigan does include ability to transcribe, a testing on their ability to transcribe?
That is what they profess. I haven't dug deep into the any of their syllabuses or their rubrics, but based on the description, they say that they do give them that they require them to be able to transcribe.
Out of curiosity, do you have any idea how many out-of-state licenses have been granted during the pandemic?
We not more than usual. We get more of a trickle, but I have not seen a wave. And when I say that, I mean, of course, I'm just pulling that. I don't have, these aren't hard data. That's just me approving these as they come through, right? So without that, just to sort of give you a snapshot, a couple a month, something to that effect. I have not seen a wave of these coming through yet.
Okay, I ask because it's a problem with Zoom that reporters can hop on anywhere and take depositions without being licensed. So they shouldn't, but they do.
Right. And we've had some questions to that effect, and you're right. They would be subject to the laws of Tennessee should they be taking any depositions. With the proximity or platforms, electronic platforms do not change that fact. So, where that happens, we'll handle that through the complaint process as we're made aware of that. It sounds like what we have before us then is we're waiting, or if that be the will of the commission, we're waiting on a motion to accept CSR and CSMR for reciprocity, unless there's any more comments on that. And then I'll bring you more information for CER at the next meeting, whatever they'll provide and make available to me.
Yeah, this is Britton Collins. I make a motion that we approve reciprocity with Michigan for their certified stenomask reporter and certified stenographic reporter classifications, but that we defer consideration of the certified electronic recorder designation and request that the department get more information about what exactly the examination is that's accepted in Michigan for approval of that designation.
Thank you for that motion, sir. Do we have a second in regards to that?
Second by Judge Rambo.
All right. Thank you, Judge. We have a motion from Britton Collins and a second from John Rambo to accept the CSR and the CSMR and to defer the CER into the next meeting until we have more information to review. Do we have now for roll call vote then? Britton Collins?
Mr. Kupchak,
Yes, ma'am.
this is Marilyn Morgan. Is there room for one more question?
Sure, of course, absolutely.
Okay, my understanding after corresponding back and forth with some of you guys, because we grant them reciprocity, doesn't mean they have to grant it to us. Is that right?
That's correct. But everyone that we do approve reciprocity, we send a reciprocity agreement to that state for their consideration and signature as well. So we do follow up in that regard. All right, any more questions then? Okay, roll call vote then. Unless there's any further discussion, roll call vote. Britton Collins,
Aye.
Judge John Rambo,
Aye.
Marilyn Morgan,
Abstain.
Brandon Pettis,
Aye.
Stephanie Branham.
Aye.
All right, thank you. Moving on then, I think we're ready for the legal report, of which part of that's already done. Thank you for that. So it looks like we're ready for the legal report.
Oh, you bet. On the legal report for today's meeting, there are a total of 4 cases. Did you want me to read the case numbers now or at the end, Leona?
If you could go ahead and read them now, that'd be great, just to kind of get that into the record on the front side. That'd be great.
Okay. Total of 4 cases. Number 1, 2020-74181. Number 2, 2020-08056. Number 3, 2020-094601. Number 4, 2021-012781.
All right, great. Typically, we just open it up to everyone to see if they have any questions or comments about specific cases before we read the recommendations. Does anyone have any questions in regards to the legal report?
Excuse me.
Okay, Hugh, I'll defer to you however you want to roll from here.
Okay. Well, the recommendations are all for close, except for one in which a civil penalty will be issued for $250 for practice of reporting with an expired license. If there are no questions there, then I can read the case numbers again and add the recommendation to the end of there.
Yeah, that'd be great. That'd be good. Thank you, sir.
Alrighty. Number 1, 2020-74181. The recommendation is closed. Number 2, 2020-08056. The recommendation is closed. Number 3, 2020-094601. The recommendation is closed. Number 4, 2021-012781. The recommendation is to authorize for formal hearing, issue a $250 civil penalty for unlicensed practice of court reporting, currently expired, suspended, or revoked in violation of Tennessee Code Annotated 20-603A.
All right. If that be the will of the commission, we'll need a motion in that regard. Do we have such a motion, or do you have any further comments or questions?
Glenn, I'd like to move that we close as listed case number 1, 2, and 3. And I'd like to take up number 4 separately.
Yes, sir. Okay, that we can do that. So we have a motion to close case number 1, 2, and 3. Do we have a second in that regard?
Marilyn Morgan, I second.
All right, thank you, Ms. Morgan. For roll call vote, Britton Collins,
Aye.
Judge Rambo,
Aye.
Marilyn Morgan,
Aye.
Brandon Pettis,
Aye.
Stephanie Branham.
Aye.
All right, great. Those 3 are taken care of. So on to number 4 then, Judge.
I thought maybe we might have more discussion on that one. It seemed since
Okay.
there's a penalty, the other 3 seemed
Sure.
easier. So I'm trying to move
Yes,
the
sir.
agenda
Yeah.
on that. I
Um,
don't have a strong opinion on this one.
okay. Hugh, do you want to read the summary then, just to sort of put that front and center in our minds?
Sure, I can do that.
Thank you.
Summary is, this complaint alleges that the respondent refused to excuse me, to provide the transcripts for court reporting services rendered during a hearing. The complaint also alleges unlicensed activity. For the allegation regarding refusal to provide transcripts, the respondent stated that the transcript has been provided to the complainant. The complainant confirmed the transcript has since been provided. As for the allegation regarding unlicensed activity, the respondent's license is expired. The respondent works as a court reporter that provides court reporting services in state criminal courts. Public Chapter 450 exempts from licensure court reporters providing services in state criminal courts as a per diem court reporter compensated by the administrative office of the courts. Here, however, the respondent admits to providing the services at issue during a civil trial because there was not enough work at the criminal court due to the pandemic. The respondent's position is that no license was needed because they worked as a court reporter for the state criminal court. While it is true that the respondent would be exempt from licensure had they been providing services in capacity of their work as a state criminal court reporter, the respondent was required to renew their license to engage in court reporting in a civil matter such as the matter at issue here.
Is there any follow-up questions from our board in regards to the details of the case?
This is Britton Collins. With respect to the recommendation and the issuance of the $250 civil penalty, it is really what we're discussing here, presenting a consent decree to the respondent with the $250 civil penalty that they can either accept or decline, in which case they would move to a formal hearing.
Yes, sir, that's correct.
Yes, that is correct.
Sorry, Hugh.
That's okay.
Do you know if there's other complaints related to this respondent, or is this an isolated incident?
This is, as far as I know, it's an isolated incident.
This is Britton Collins. I move that we accept disciplinary counsel's recommendation authorizing a formal hearing and the issuance of a $250 civil penalty for case 2021-012781.
All right, we have a motion to accept council's recommendation. Do we have a second in that regard?
This is Brandon Pettis, and I second that motion.
All right, thank you, sir. We have a second from Mr. Pettis for a roll call vote. Britton Collins.
Aye.
Judge John Rambo.
Yes.
Marilyn Morgan.
Yes.
Brandon Pettis.
Yes.
Stephanie Branham.
Aye.
All right, great. Thank you very much. That concludes the business on the agenda. Do we have any new business, or excuse me, before we move on, Hugh, did you have anything else that you need to share with the board?
The only other thing I could think of was I didn't get a chance to finish on my rules update.
Yes,
Essentially, we talked about the substance of the amendment and all that, but I just want to make sure the board was clear that it's once the Attorney General's office approves the red line as it is, the next step in the process is that these rules are going to be filed with the Secretary of State, and then I will post a second e-notification. And then after that, we will go before the Government Operations Committee, which puts I can't say what the effective date for the rules will be because I won't know until they're filed. But it most likely will put the effective date somewhere around June, July, and that's just a guesstimation. It could be later than that, but I just wanted to make sure the board was kind of aware of what the next steps in the process were. And that's it.
All right, thank you, Hugh. I appreciate you tracking that for all of us. I know you put a lot of work into it, and there's a lot of back and forth with all the parties and stakeholders internal. So, and I appreciate your work in that regard.
Oh, absolutely. Anytime.
All right. It looks like we're done with what we have on the agenda. Do we have any new business? Okay. Hearing none, I think we're ready for adjournment. Do we have a motion to adjourn?
Marilyn Morgan, I make a motion to adjourn.
All right. Thank you, Ms. Morgan. Do we have a second?
Stephanie Branham, a second.
All right. Thank you, Ms. Branham. For a roll call vote, Britton Collins.
Aye.
Judge John Rambo.
Aye.
Marilyn Morgan.
Aye.
Brandon Pettis,
Aye.
Stephanie Branham.
Aye.
All right, thank you very much. We are adjourned. Thank you so much for carving out time for us this morning.
Thank you, everyone.
Thank
Thank you. Y'all take care.